Good afternoon. I'm Gary Allison, Vice Dean at the College of Law. Welcome to our latest Faculty and Alumni Showcase series presentation. In front of you there is a blue bulletin that lists other events in this series that will be forthcoming in the not too distant future, and we certainly encourage you to come back and participate in all of our faculty and alumni showcases. It's a pretty good deal. You get CLE and a free lunch. And it's hard to beat that deal almost anywhere. It's my great pleasure today to introduce our featured speaker, Richard V. Risk, Jr. Dick and I go back a long time ago, back when he was an executive with a public service company and I was on the side resisting a nuclear power plant. And my spouse at the time was working with Dick at PSO. So we have a long history, but over that course of events we grew to respect each other, and I never thought I would see him at law school. But at age 57, he walked into law school a man with a mission, because he had discovered and working in this business of structured settlements as a non-lawyer that people were gaming the system to the disadvantage of the victims, the people that these structured settlements should have most benefited. And as a consequence, he realized after lobbying efforts to change the rules, after working within the industry to change the rules, that this just wasn't going to work, that he would maybe have to go another route, and when the legislative process doesn't work, you can't get an industry to change its own standards. Where do you go? You go to court. And he really at that time believed he was going to have to be the one to go to court, so he marches into law school at age 57, leaves with a degree at age 60, believes that joining a law firm as a junior associate wouldn't be appropriate at that age despite his stellar academic career here, and begins to operate on his own. But all this time he's been building the theories about how to take this case to court, get a test case, a class action to court. And after receiving his law degree, he convinced 3 other law firms to take a strong look at that. They joined up with him to file a suit that resulted in a $72.5 million settlement on behalf of people who had been on the wrong end of these structured settlements. Now, from time to time, you see dramatized stories about whistleblowers, and Dick is in that honored tradition as a person who worked within an industry, wanted that industry to do the right thing, could not get the changes made within the industry, and then moved on a multi-year quest to make this change happen. And so we are deeply honored today to have Dick Risk to talk to you about his experiences. I think not only will you learn something about a specific topic, the settlement process, structured settlement process, and what went wrong and what now is going right, but you'll also learn something about how to do these kinds of things yourself, maybe be inspired to do something like this yourself. And one abject lesson that I take away from Dick's experience is the current trend in politics to take away people's access to the courts of law is exceedingly dangerous, because the legislative process is bottled up by lobbyists, vested interests. You can't get much done there. They certainly don't reform from within. If we lose broad and liberal access to our court system, then we will be stuck with the results that the political system provides, which often is an injustice. Dick, thank you so much for being here.
I don't know if I can live up to that. I have to say this, that when I was at PSO and I was essentially the public relations manager for a nuclear power construction project, and I challenge anybody to take on that kind of a job if your last name is Risk. And the guy I reported to at PSO was an executive VP, later president, by the name of Martin Fate. So the detractors had fun with that. The other thing I'll say is that I congratulate the law school on its raising its admission standards and just the quality of students here, and I'm proud to be from a school that probably if I applied today I couldn't get in. And Gary already kind of covered my topic, so with that, thank you very much for me. Just out of curiosity, I kind of like to ask who's here. How many of you are attorneys who practice in maybe insurance defense work? Nobody? Okay. How many of you are plaintiffs advocates and represent plaintiffs in the litigation? I know Joe does. And how many of you are students? Okay, good to have you. You don't look old enough to be students. You have to be in your 50s, I think. And then are there others here who aren't students or lawyers or whatever? How many are here for the free lunch? Well, I'm here, and as Gary said, I became a lawyer actually 5 days before I turned 60. I missed my graduation because of a scheduling conflict, but my wife had a birthday party for me after I came back, and I wore my medieval hat to the party. And I guess I was invited here today. A couple months ago, Dean Levitt invited me to lunch when I had sent out a copy of the court order on our class action settlement, and Gary received a copy, and next thing I knew I was being invited to lunch. There is no such thing as a free lunch, I'll just say that, but I did get invited to speak here today, and I said, well, what will I talk about? And Dean Levitt just said, we'll talk about what you and I talked about at lunch. So I've kind of made some notes here, and I'll try to follow that. And if I run over, just let me know, or just walk out. But I did want to make this disclaimer that I am highly biased in favor of injury victims. So this presentation will be highly biased. I graduated from Oklahoma State, undergraduate with a BA in radio and television, went right into the Air Force as an information officer. And when I got out, I worked for Getty Oil and for about a year and a half, and then kind of found a job at PSO. They said, we're looking for somebody with nuclear experience, and I had been in the Strategic Air Command, which had a mission of delivering nuclear weapons by airplanes and missiles. So I was hired. And then after that, I somehow wound up as the administrator of the Southwestern Power Administration, which is a power marketing agency for the Department of Energy, and was in the senior executive service. I was an appointee, and it was kind of neat because I had gotten out of the Air Force as a captain and went back equivalent to a 3-star and visited some of my former colleagues. In fact, I was a general's aide on Guam for a couple of years, and general I worked for retired as a 2-star, and it was it was a 7-day-a-week job, and we were in the middle of launching B-52s every day, and I went to visit him, and he was thrilled, and until I told him that it was equivalent to a 3-star, but that he could still call me Dick. And then somehow I gravitated to the life insurance industry when I left that, and was trying to sell life insurance, and I hated it. And one of the attorneys I called on, who I'd known at PSO, said, well, do you do structured settlements? And my answer was, I'm sure I do. Didn't have the foggiest idea what they were, and did a little research, and there really weren't many articles on that at the time. It wasn't a body of literature as there is today. And so I did a couple of them, and discovered very quickly that this was kind of skewed toward the insurance industry and corporate defendants. And so that the injury victim was really being not treated fairly in all respects. And I would go to mediations, and somebody would show up from the other side and say, well, this is my case, I'm representing AIG, or I'm representing so-and-so, why are you here, and whatever, and it was a battle. And so I decided to take it on. After several years of being on the sidelines or being on the periphery of this industry, I decided to go in full time and be a plaintiff's advocate. Now, how many of you don't know what a structured settlement is? All do? Okay. It's essentially a settlement of a claim. It doesn't have to be a personal injury claim, but it's a settlement of a claim that involves payments that don't occur all at the same time. And that's pretty simple. It's usually funded by an annuity from a highly rated life insurance company. You can use treasury bonds in a trust, but there have been some cases where the trustee wasn't so trustworthy. So most of the structures today are done by insurance companies, and you have the backing of these highly rated companies that are institutions that have been around for a long time. If the payments arise from a personal physical injury or physical sickness or from a workers' compensation claim, the payments can be excluded from your gross income. And the benefit of the structure, besides being something that you don't have ownership of the annuity or the funding asset, so you can't really invade it. There are procedures now through what's called factoring, but you have to go to court to do that. But besides the spendthrift protection that they inherently offer, there's a tax benefit if, for example, you're funding payments for a birth-injured child, and it's funded with an annuity that costs $1 million, but over the lifetime of the child it pays $1.5 million or $1.7 million, something like that. All of the growth is tax-free as well. So those are the benefits, but they have to be done at the time of settlement, and they have to be done from the defense side, and that's how the insurance industry figured out, first off, that they could do what's called bridging the gap. That is, that they could use part of the tax benefit to benefit themselves, and then use the time value of money, and they could show, well, if we spend this amount of money, it's going to grow to such and such an amount. And it is a good deal, and they are enhancing what can be done. But as the industry developed, the insurance industry and the corporate defendants learned also that they could do this and profit. They could do what's called underwriting for rated age. That is, that if somebody's health status, health history suggests that they're not going to live a normal life expectancy, and you're going to make annuity payments for life, the insurance industry underwriters can assign what's called a rated age. That is, somebody who has maybe a chronological age of 6, but the underwriters say, well, they have the life expectancy of a 25-year-old or a 30-year-old. So when the payments then are determined, the payments are greater if they're to be paid for a lifetime. And essentially all you're doing is paying out the same amount of money, theoretically, but over a shorter period of time. But there's a benefit to that. But what was going on is the insurance industry was saying, and they still do this today in some cases, is saying, well, we'll pay X amount of dollars for these benefits, or they will say, we'll provide these benefits, and they'll show an annuity illustration, and they'll represent what the cost is going to be, but then they'll go back and underwrite it after the fact and get it for a cheaper rate. And, they used to call that fraud. I guess they still do. And then you had the marketing schemes that some of these structured settlement brokerage houses would do that involved rebates or commission sharing agreements. That is, that if you're, and I can name names, I guess, here, Ringler or SFA or some of these firms have these contracts with defendants, with casualty insurers, and with self-insured corporations that involve sharing. There's a 4% commission on the annuity product, and that's pretty standard. And some of these companies were demanding, after they had been offered these sort of thing, were demanding 1%, maybe 2% of that commission. Well, if you're representing in a settlement that you're going to spend X number of dollars, say $100,000, but you're going to get back 2% of that, what is that, $2,000? You've kind of made a fraudulent misrepresentation when you do that. So I kind of became a student of structured settlements, and I started writing articles. When I first started writing, I was just talking about the merits of structured settlements and how they can benefit and kind of how they worked. And then I started writing about what was going on in the industry, and very quickly, as you can imagine, the National Structured Settlements Trade Association kind of considered me the scourge, and they didn't like me very much, and I published in articles, mostly trial lawyer magazines across the country, I think in about 15 states. And then I started doing a newsletter that I called, very creatively, Structured Settlements, and would here's one that's the definitive guide, and this is kind of a compilation of various things, but I would publish these quarterly and send them out not only to my own client list or potential client list, prospective client list, whatever, but I would market these to other people in the business who wanted to have, get in front of their prospects on a regular basis. And so I would remake the back page and put their picture on it and their little biographical sketch. And at one time, at the peak of this, we were doing about 15,000. Our press run was about 15,000 each quarter, and it was going out to the insurance industry and lawyers all over the country. And so they kind of got a feel for, hey, this, the structured settlement concept is okay, but maybe we need to be more aware of what's going on. The posture of the industry then, of the National Structured Settlement Trade Association, was to preserve what they had. And this wasn't just to preserve the advantage for those who were engaged in the defense side, but also just to set up barriers to entry so that people with an insurance license, that's really all it required, people with an insurance license could get into the structured settlement practice, and they would, represent that this was rocket science. It's not. I think you could train a monkey to do annuity quotes and be present at a mediation with a laptop. Where it gets a little complicated is when the non-lawyer writes the documents using templates that the association puts out, and the lawyer just accepts those. So you have, practicing law without a license. I did that before I became a lawyer. I'm guilty. The defense brokers would say, they wouldn't tell you, initially they wouldn't tell you how much they spent on the annuity. They would say, here's some periodic payments, and if you live to be 80 years old, it's going to be, $1 jillion, and we only spent a few dollars to do it. And they'd say, well, if we tell you how much we're spending on the annuity, that's constructive receipt, and it's going to ruin all your tax benefits. Well, that was an untruth from the beginning, and there were a couple private letter rulings from the IRS that said knowledge of the amount is not constructive receipt. You see, you can't own the asset that funds the payments. Usually, what happens today, most structured settlements are done where the annuity is actually purchased by a third party. And that third party is a shell company owned by Allstate or AIG or formerly the Hartford and a few other companies, MetLife. And so what happens is the defendant or the insurer, the liability insurer for the tortfeasor says, well, we'll agree to these periodic payments, and that will establish that obligation, but then you're going to let us make an assignment to this third party, and so then they just pay the amount to the third party company. They buy an annuity from their own life insurance entity. They own it. Periodic payments are made, and then the liability from the original defendant or the original insurer is extinguished. And there is a section of the tax code that allows for that assignment, if it's for qualified money, for money that's excluded from gross income, that makes it possible. So the original obligor then gets to write off the amount they're paying in the current year. They get to take it off their books. Yes, sir.
Is this okay time to ask some questions?
Sure.
All right. I participated in a couple of structured settlements where these exact questions were coming up, which were, how much are you going to spend of my client's money or my money that I've got structured for part of my fees? How do I know how much money you're going to spend on the annuity? They tell me, well, at first they wouldn't tell us, and then they ended up telling us.
Yeah, if I tell you, it's going to constitute constructive receipt, and therefore...
They didn't say that. They just said, well, no, here's your benefits. Don't worry about how much we spend. Just here are your benefits. All right, so then we get to the question, how much of my money and how much of my... For a disabled person that you're representing the guardian for, how much are you spending of the ward's money to buy this? They tell me they're spending the exact amount of the settlement money on it, which then tells me, well, how's this third-party broker making money on this? Which means that they're discounting something, somebody's getting a kickback or something.
Well, there is a commission built into the price of every annuity. It's 4%. And so that broker is getting 4%. And I'll get into that in a little more, but that's kind of why these brokers go to the insurance companies and say, we will be your exclusive person, we'll accompany your claim adjuster to these mediations, and you don't have to pay us. So it's all about who gets paid the commission.
But where's the commission come from?
It comes from the life insurance company that issues the annuity.
Okay.
And it's paid to the person who does the annuity transaction. And let me just touch on this right now, is that my issue with all of this is that person who, they call themselves brokers, but they're not. They're life insurance agents. A broker is really somebody who is independent and has no duty of loyalty, but these people have a duty of loyalty to that life insurance company because they're an agent for them. But anyway, that's another issue. But when they come into a mediation or settlement conference or whatever, they're there at the invitation of the defendant or the defendant's liability insurer. They're an agent of that person. So when that release is signed, that settlement agreement and release is signed, you're releasing not just the tortfeasor, but their insurer and all their agents. So that person is there to really help facilitate that mediation and that settlement, and that's how they're getting paid. Well, that's not of any direct benefit to the plaintiff. My contention all along was the plaintiff ought to be able to choose that individual to handle the structured settlement and get compensated from the commission. Because in the early days, when they wouldn't tell you how much the annuity cost, that was really kind of not an issue, except that the lawyer needed to know so the lawyer could get the contingent fee. You know, if they had a 30% contract or 40%, whatever, they needed to know that. But then when they started saying, we're going to spend $100,000 on this annuity, and part of that money was kicking back to them, but the other part was being paid to that person who represented them, whose objective was to try to settle this thing for as little as possible. Well, that wasn't benefiting the plaintiff. So my argument was that the plaintiff is really losing part of what was promised to him or her when they could have been using that money to pay their own consultant who had a duty to them and whose duty remained then, whose liability remained to them after the settlement. They were not dismissed. Okay, and that kind of gets into our theory in the Hartford case that I'll touch on. And by the way, most of the articles that I did over this 11 or 12 year period are on a website that I put up initially for my structured settlement business that my son now has. I guess he still has them up there too. But then I have a website for my law practice. I'm solo, and it's risklawfirm.com. And there's just a lot of articles there, and people will go to that quite frequently. I get to see how many hits it gets, and a lot of people who are just trying to learn about structured settlements will go there. I became known as a plaintiff's advocate, and somehow I got steered to a gentleman, or actually he got steered to me in New York, a lawyer by the name of Ralph Stone, who was putting together a class action in Connecticut against the Travelers. And the case was called Macomber, M-A-C-O-M-B-E-R. Lisa Macomber, on behalf of her son, versus Travelers Insurance Group et al. And it was in state court in Connecticut. And I got called in, I think it was as he was filing the suit, but maybe it was a little later. And he had filed it, and the trial court had dismissed all of the causes. And the Supreme Court then had reinstated about 7 out of the 10 causes and remanded it back to the trial court. And anyway, I worked with him and kind of educated him on structures. And this is before I really intended to go to law school. And trial court then certified the class. And it went back to the state Supreme Court, and the Supreme Court rejected it on certain issues. But the beauty of that was that the Supreme Court then had really laid out a roadmap as to what it would take to certify a class on these theories of fraud. And that case eventually settled. I don't know the terms of the settlement, but that gave us a roadmap later on, because as we filed our federal case in Connecticut, under the Erie Doctrine, of course, the courts are obligated to use state law, to apply state law. And so we had this roadmap for getting class certification, and it worked. I did a lot of things to try to change the way industry was done. When the tax law was changed in 2001, kind of as a rider to the Victims of Terrorism Relief Act, to allow for these factoring transactions, but it also required, the federal statute also required that you go to state court and get approval in advance before you factor these things. Anyway, the structured settlement industry and the settlement purchasing industry had agreed on this compromise, and so they were trying to get every state to pass what they were calling the Structured Settlement Protection Act. And when that occurred, the trial lawyers organization in Oklahoma came to me and said, well, what do you think? I said, well, if they're going to call it a protection act, let's put some protection provisions in there and protect the plaintiff. And so I drafted some language that would allow the plaintiff to choose and whatever. And Brad Henry was chairman of the Senate Judiciary Committee at the time, and he sponsored it for a couple years. And it would pass the Senate and then go over to the House and get defeated by wouldn't make it out of the Insurance Committee, which was kind of controlled by the insurance industry. And in fact, the third year, Jerry Smith of the other party sponsored it, and it similarly got run out. So I guess that's about when, I'm trying to think, I was already in law school by that time, but that's when I decided that, hey, the only way to do this is through litigation. I think there's a class action here somewhere, and I think I can figure out the theory. going back to my time in law school here, I graded onto the Tulsa Law Journal, now called the Tulsa Law Review, and published an article, or a comment, I guess, because I was a student on structured settlements. And as I said, there wasn't much literature at that time. This is one of the, what I call one of the thin books. There wasn't much literature on structured settlements, and so as I was writing this, and I was making some statements, and the editor, also a student, called me and said, "Well, Dick, where are your citations for these statements? You're a student. You have to have some expert, some authority to cite to." I said, "Well, I'm the authority." And so I remembered reading an article by one of the professors who's no longer here, Larry Backer, and he was citing to himself. And so I thought, well, gosh, I've had these articles published all over the country by these trial lawyer magazines. So we cut a deal, and I cited myself in this article. And I called it, what did I call it? Structured Settlements, the ongoing evolution from a liability insurer's ploy to an injury victim's boon. And it certainly had an impact. I sent out copies of this. I ordered some extras and mailed them to all my friends and adversaries in the structured settlement industry, and it kind of had an impact on the structured settlement, National Structured Settlement Trade Association. By then I had quit that organization when I realized that they were taking my $1,000 a year dues and using it to work against my interest. And I'm still kind of the scourge there, but I was a founder of a group called the Society of Settlement Planners, and we'll always be a small organization. I think we're probably, the number's kind of a moving target, somewhere between 45 and 60 people, and we formed this in 2001, about this period, and earlier this year they made me an honorary life member or something like that. I'm the first and only, and I don't know. I'm proud of that. But anyway, I said I went to law school. I graduated in 3 years, part-time, because I went overseas in the summer and was sworn in the next spring in April of 2002. So I'm still a young lawyer under the Oklahoma statutes because I haven't been practicing 10 years. But I was exempted from CLE requirements about 4 years ago, 5 years ago, maybe something like that. So go figure. I found a niche practice doing these qualified settlement funds. Essentially what that is a trust that you set up with created by an entity of government, and in this case it's the court. And what it does is allows all the funds, all the settlement proceeds to be paid into this trust. The original defendant is dismissed and released, and then I become, or the trust becomes, a substitute defendant, or a replacement for the defendant. It's called a novation. It's an agreed substitution of parties. So the money is paid in. The plaintiffs still have their claim to the tort claim. It hasn't been resolved yet. I have the money which they've agreed is sufficient to extinguish their claim. So we agree on this payment, and we can do a structured settlement. There's a revenue procedure that says I can do the same thing an original defendant did. Well, imagine the impact that's having on the defense organization, because it's taking away their ability to control these things. Now I've done about 250 of them. They're coming up with theories of single claimant causes economic benefit and whatever, and that's kind of another story too. We went to the IRS in 2004. The Society of Settlement Planners did, requesting guidance, and that's pretty gutsy to go to the taxing authority and saying, give us a published guidance on this thing, because all these prestigious lawyers from Hogan and Hartson were saying, oh, it doesn't work. And so I wrote this article for the Virginia Tax Review called "A Case for the Urgent Need to Clarify Tax Treatment of a Qualified Settlement Fund Created for a Single Claimant." And that was about the week the editor said it's in final form. I emailed that to about 20 people in Treasury and the IRS, and then all of a sudden it's on their to-do list. And it was on there about 5.5 years until a year ago when it was just removed. And so I was back there this last February testifying on a rule change, and I tried to bring this up again, and the hearing person said, well, we're not going to explain why we took it off. But then I said, well, there's still a need for this. And she said, well, have you thought about applying again? And I said something like, that's absurd. Anyway, I noticed now the American Bar Association has requested that this issue be put back on there. I'm trying to watch the time here, too. Let me talk a little bit then about the Hartford case. In about 2004, I did find a law firm, and they recruited a couple other law firms who thought I had a pretty good theory. It was a little difficult to articulate. The theory was that this 4% money, here you had Hartford Property and Casualty Company, there were about 5 or 6 property and casualty companies. Then you had Hartford Life. And, of course, everything went to the Hartford bottom line. And these casualty companies were instructed that they had to use Hartford Life as the annuity. You couldn't really go outside. Maybe there were some rare exceptions. So if you're a settling plaintiff and Hartford says, we're going to spend $100,000 on the annuity to fund your future payments, and we're going to use Hartford Life annuity, who would guess that that third-party person in there is going to get a commission and to benefit the Hartford? And so part of what they were promising you was really going to pay their person. Now, Hartford also had a 1% kickback, but that wasn't really relevant. I wanted to take that McCumber theory, which was on the 1% kickback for travelers, and just say it's not just the amount being kicked back, it's the full 4% because it's not being disclosed. And when you say we're going to spend $100,000 on your future benefits and you only spent $96,000, that's fraud. So, but the argument against that was, well, even if you get to select your own broker, that 4% is going to be paid to somebody. But it's going to be paid to, I mean, my argument was it's going to be paid to somebody that they select who has a fiduciary duty to them and will remain on the hook after the settlement. So that was the problem, is that the plaintiffs were being harmed by the fact that they weren't getting the full benefit of what that commission could buy for their benefit when they were being offered this. So in the discovery process, we found that it was not just 4%, but there was a pie chart that the structured settlement people had used to brief the CEO of the Hartford. 15%. It wasn't just the commission. There was actually 5% for marketing, which covered the commission, but there was another 5% profit. There was another couple percent for taxes that they had to pay and things like that. Well, arguably some of these parts of the pie were debatable, but we revised our complaint, and anyway, to kind of shorten this story, we filed in federal court in Connecticut, federal district court, and we alleged several things initially, but the court certified the class on fraud and violations of RICO. Racketeer Influence Corrupt Organization Act. And the theory there was that the typical racketeering enterprise consists of several entities that aren't related to each other and aren't really part of the enterprise. I know that's difficult to kind of conceive here, but so what you had was the Hartford, and then they had these programs with about 6 brokerages that were all in this enterprise with them, all designed to defraud the injury victim. So you had a racketeering enterprise. But we filed only against the Hartford. We didn't want a room full of lawyers defending all of these other brokers and, you know, filing motions and everything else. So they were part of this alleged enterprise. The certification was appealed to the Second Circuit. Second Circuit ruled that the judge did not abuse her discretion in certifying the class. And so last February, we went to our first mediation in New York, in the New York Times building, beautiful setting. And it wasn't that successful. They didn't really come to play. I think we left maybe $12 million on the table or something like that. I probably wasn't supposed to give that number, and it probably isn't the right number, but it wasn't quite what we were looking for. But the second time was in April, and they agreed. We agreed that they could say they admit no wrongdoing. Okay, we had alleged fraud and racketeering, so there's no admission of wrongdoing, but they agreed to pay $72.5 million. Apparently they didn't want this to go to trial. And they reported it to their shareholders as $45 million after-tax write-off to, you know, kind of downplay it. But we thought that was pretty significant. The size of our class was 22,000 plus. The court approved it in September. We had to send notices, sent 2 notices out, and I've given you a copy of the notice that appeared in the USA Today. I think when we had the proposed settlement, it's kind of abbreviated. If anybody wants a copy of the court's order approving it, the court awarded us about $850,000 in cost reimbursement, and awarded the attorneys a 30% fee, and I had a piece of that. And so, and the money is just now being distributed, I think probably next week, I hope, because I get calls all the time. The court has appointed an administrator. It is a qualified settlement fund, and they're supposed to be making these checks out. And the beauty of this is that people are getting about 3.5% of what their annuity cost purportedly was at the time of settlement. That's better than a coupon, I tell you. On the average, it's going to be about $2,200 to $2,500 a piece. After the fee, some people are going to get a significant amount because their pro rata share will be predicated on their individual annuity costs. Some people will be getting very little, but it'll be a nice little piece of change for them. A few lessons from that. Number one, most of these people who settled, these 22,000 people who settled, and by the way, our class was only for those people who did not have a structured settlement broker on their side. If they had somebody representing them, Hartford didn't really agree to splits of commissions, but sometimes that occurred. But if they did not have a broker on their side, then presumably they were not aware of that 4% commission, and that was where that was the element of fraud. Most of those people were represented by counsel in the negotiations in the settlement. Now think about that, 22,000 cases where the lawyer representing the client wasn't really aware, or maybe kind of had a suspicion, but maybe just was interested in the fee and didn't want to hold up the settlement. Okay? But then think about the other side. You have attorneys in most cases. You had attorneys. Sometimes the claim adjuster would settle directly with the claimant, and you have to be really stupid, I think, to settle a claim without being represented by an attorney. But in most of these cases, they were represented by the defendant. The insurance company was represented by an attorney. Now, the attorney works for the insurance company. That's the employer. But who's the client? The client's the tortfeasor. That's the insured person who caused the accident. Is there a conflict of interest there? Yeah, there's an inherent conflict of interest because that attorney is going to put the interest of the employer ahead of that of the client. And so when Sometimes these settlement agreements have terminated, or settlements have, negotiations have broken off because the defendant is saying, we insist on using our own person or whatever. But that's, that's not really in the plaintiff's, in the defendant's best interest, because if that case isn't settled within policy limits, then and it goes to trial, then there's probably a first party bad faith that they could assert against the insurance company for not allowing it to settle. But my point is that all of these lawyers, and you have to be really stupid to not pick up when the claim adjuster says, oh, we have to use so-and-so to do our structures. Why? Well, because they have to watch out for our interest. Wait a minute. You're going to pay $1 million. You're going to write a check, totaling $1 million, including the cash and the annuity. And you're going to get a release, and the court's going to release you once and for all. What's the problem here? But you really have to be stupid not to suspect that something was going on. So it happened at the Hartford. Hartford got out of the business right after the court, the Second Circuit, approved the class certification. They got out of the business. I think that there's also one thing that's unresolved here, and that is that RICO violation is a criminal act. And all of the attorneys general of the states where they do business were notified of this. And I don't think any so far have shown any interest. I'm going to probably send a copy of the court order to the attorneys general and ask them why they're not looking into this. Hartford isn't alone. It's still going on out there. I could name the other companies who are doing it, and maybe we're looking at having more of an impact and going after them. I also think the Department of Justice torts branch, we could make the same racketeering theory. Can't go against the sovereign for racketeering, I guess, under the Federal Tort Claims Act, but we can certainly name the cronies and maybe send a chilling effect as to what they're doing. But that's a different story also. So finally, and I know we're kind of running out of time here, but one other thing I wanted to touch on is I've also distributed to you a copy of the Standards of Professional Conduct for Settlement Planners. I was asked by the Society of Settlement Planners a few years ago to take on this project of writing a code of conduct, some ethical rules for structured settlements. And it's pretty difficult because we were really essentially just representing the plaintiff's side, but I first went out to people who had been involved in standards of conduct for other organizations like the certified financial planners and people like that. And then one person kind of surfaced, a guy named Carl Pierce, who was a distinguished law professor at the University of Tennessee at Knoxville and had been a reporter for the ABA when they revised their model rules. And so I asked Carl to help me with this. And we worked on it about 2.5, 3 years. And eventually these rules were adopted by the Society of Settlement Planners in 2009, March or April. It's on there. It's not binding. It's binding only on the members of the Society of Settlement Planners, but in the absence of other reasonable rules out there, I can tell you the National Structured Settlements Trade Association adopted kind of a farce thing in 1997 and then immediately issued a letter saying that they weren't going to enforce them. So, go figure. So what I hope might happen, well, they don't have the force of law. They could wind up being the de facto rules if some court adopts them in some kind of a dispute. So we're hoping that occurs, but I just suggest that this is a good thing to look at because it kind of talks about the structured settlement industry and some of the things that happen and some things that we believe are not ethical. We did mail these out to everybody in the business that we could identify, including all the members of the National Structured Settlements Trade Association. I think it's having some impact. The industry's not cleaned up yet, but we think we made some impact. So that's my story, and I'm sticking to it. Thank you. Joe.
Why can't the injured person go out for bid to a lot of these and say, I've got $1 million, what will that buy me in the way of a 10-year, 20-year lifetime?
Yeah.
Does that make sense?
Oh yeah, it makes great sense. The problem has been that in order to do this structured settlement, the payee can't own the annuity or can't have any incidents of ownership. So the defense says, well, we've got to do this. This has to be an agreement between the adverse parties. But with a qualified settlement fund, they don't like that. The cases I get involved in are $1 million on up. I've had them as large as, I think, $49 million was the biggest, and so that's a lot of money that I've handled with these things. And that works. And then you say to the plaintiff, actually it's the plaintiff's attorney, or sometimes the structured settlement person who wants to work with the plaintiff, who brings me into the case. And part of my fee is covered by the earnings of the money while it's in the QSF. The other part is just paid out of the proceeds. But yes, that's right. And so this person can go out and bid this, and present. Some of these people will do what they call full market surveys, and they'll go out to all the companies. That list in that newsletter is 3 years old, but it's not current. I think it has the Hartford on there and a few others. Some who've gotten out, some have gotten back in the business. But they can go out to these companies and then shop it. And you don't necessarily want the one that has the best payout. You want to look at ratings and whatever. And sometimes you'll split them up. I've done cases where they split them up with 4 different companies. Does that answer the question? Yeah.
Yes.
Okay.
Does every person who's currently receiving a payment or has received one have a cause of action in which they can now pursue? Many people have not benefited from the work you've done. What about all these other people who have a lesser settlement because of the actions of the...
I think those who settle with other companies, now those who settle with the Hartford and were in that class definition, they had an opportunity to opt out. In fact, we had 49 people opt out, and then that was after the first notice. And then when we settled tentatively for $72.5 million, we got the court's permission to go back to these people and say, hey, if you want to opt back in, you may. And I think most of them did, all but a handful. I mean, why would you pursue this if maybe your claim is $1,000? You couldn't really afford to do this on your own. I mean, that's kind of what class actions are all about. Is can you adequately represent the class? This is something that they can pursue then as a group. And so what you do is you file. We had 3 class representatives, and incidentally, they all got paid. We asked for $25,000 apiece, but the court gave them $10,000 for their trouble. They were in this for 5 years, and so they file on behalf of themselves and all others similarly situated. So 22,000 people in that class, their claims against the Hartford are extinguished, and they are being paid their pro rata share. But yes, I think there are some opportunities out there for other people in other companies, and I'd be happy to talk to those people if you wanted to steer them to me. Any other questions? Thank you again.